Good afternoon. My name is Evan Wolf, and I'm a partner at Kroll and Mooring, part of the Chertoff Group and a member of the Aspen Institute Homeland Security Group. I'm here to introduce the next session, Striking the Balance Between Security and Liberty. We are still in a post-9/11 era, but we're also in a post-Edward Snowden era. Citizens' expectations that the government will protect them from security threats is unchanged, but their willingness to grant the government virtual carte blanche to do what they think is necessary to respond to these threats has changed. What is the right balance between security and liberty? The panel will be moderated by Greg Miller, national security correspondent for the Washington Post. Greg was among the Washington Post reporters awarded the Pulitzer Prize in 2014 for their paper's revelation about the NSA programs. He was also a finalist for the Pulitzer Prize in 2013. And with that, the floor is yours, Greg.
Thank you, Evan. Can everybody hear okay? All right. So I want to start by stealing a line from the memoir of former CIA Director George Tenet. It's not the first time that I've stolen this one. This was in the aftermath of the 9/11 attacks. He wrote that the first course of action in a crisis like this is, despite what Hollywood might have you believe, you don't call in the tough guys, you call in the lawyers. And the lawyers on this panel today have taken a significant percentage of those calls over the past decade. Bob Litt, in the middle here with the blue shirt, General Counsel for the Office of the Director of National Intelligence. Bob has been in that position since the start of the Obama administration. It's part of a long public service career that also included senior positions at the Department of Justice. Raj Day, to my left, General Counsel for the National Security Agency, a position he has held since 2012. He previously worked in the White House and served as counsel to the 9/11 Commission. Scott Charney, on the end, Vice President for Trustworthy Computing at Microsoft since 2002. Before joining Microsoft, Scott was the chief of the Computer Crime and Intellectual Property section at the Department of Justice. And finally, John Rizzo was a CIA lawyer for 34 years, serving 7 presidents, 11 CIA directors. He was the agency's chief legal advisor for 7 of the first 8 years after the 9/11 attacks, and was the legal architect for CIA operations, including the secret prisons. So our topic today, obviously, is striking the balance, the right balance between security and liberty. And I thought I would open this up by basically asking, how have we done on that? We've learned a lot more over the past year about the details of that balance. And I thought I'd ask them to open by looking back at the disclosures of the past year of the sweeping surveillance operations of the NSA and to answer 2 questions. 1, were they legal, those programs, that surveillance? And 2, were they right? And by right, I mean in the broadest possible sense. Right for the country, consistent with its values, in line with its full range of interests, economic, diplomatic, and otherwise. So why don't we start with you, Raj? Why don't you start with that one?
Sure. Thanks, Greg. And I don't know whether to be offended that the lawyers can't be the tough guys or not, but I'll just let that go. So it's been a busy year, obviously, at NSA, and you're welcome for that Pulitzer, the few of you who are here in the room. But
do you want part of it? Do you want?
So my job, as I'm the general counsel of NSA, my job is to help make sure that what we do is legal and appropriate. And so it wouldn't surprise you that my answer to that question would be yes. But I think I want to elaborate on that a little bit, because I think more important than my opinion, we can all have our own opinions, are facts. And one caveat, when I say legal and appropriate, what I mean is NSA's activities have been and continue to be conducted within the legal and policy framework that's been established by all 3 branches of government. However, that does not mean that NSA or any federal agency, for that matter, is perfect or impervious to improvement. So let me give you some facts as you think about whether our activities, NSA's activities, have been legal and appropriate. And I won't, rather than take up too much time, let me just focus on 2 particular programs that have been the subject of much discussion. The 215 telephone metadata program and what we call the 702 program that's designed to target the communications of non-US persons outside the US. Fact, the 215 program has been approved 37 times over 8 years by 16 separate federal judges. Now, A critic might say those federal judges were part of the FISC. Well, over the past year, we've had a great deal of litigation in regular federal courts about this program. To my knowledge, there have been 4 decisions that have come out over the past year in federal district courts. 3 of those 4 have upheld the constitutionality of NSA's 215 program. The lone dissenting decision out of the District Court of DC is on appeal by the federal government now. Another fact, the most recent decision by the FISC, which was issued on June 19th of this year, and is on the DNI's public website now, specifically addresses the lone outlier federal decision and addresses and rejects the arguments that it relied on, and also, importantly, actually accepted and addressed arguments that were made by amicus parties outside of the FISC. So one of the criticisms of the FISC is that it's only heard from the government historically, but the FISC, at the request of an outside party, heard arguments from an outside party and addressed those in this latest renewal. The 702 program. Fact, in 2008, the FISC Court of Review upheld in a case called In Re Directives the constitutionality of the predecessor statute to 702, which was by and large pretty similar, called the Protect America Act. Fact, over the past year, there have been a number of challenges to 702 in federal district courts as a result of the disclosures. Generally, these challenges come in the context of criminal prosecutions, where a defendant will challenge the constitutionality of this program because information that was derived from it may be used in the course of their investigation or prosecution. 2 weeks ago, the first decision came out of the District Court of Oregon in a case called United States versus Muhammad, upholding the constitutionality of Section 702. And in the last few weeks, I think we've all seen publicly the report of the Independent Privacy and Civil Liberties Board, which upheld both affirmed the legality and effectiveness of the 702 program. Both of these programs have also been authorized and reaffirmed by Congress multiple times. The 215 program, or the 215 provision in the law, was reauthorized by Congress in 2010 and 2011 after letters were sent to the Congress making available information about how that provision was being used. And those letters are now available on the DNI's website, declassified and available. The 702 program was also reauthorized in 2012. I say all that not to say that it's an open and shut case, but to give you data as you make your own determinations and think through the process of whether these programs were legal. More importantly, though, I want to emphasize that, like any agency, NSA isn't perfect, and I wouldn't suggest that the legal and policy framework we have in place is necessarily perfect. 2 places where I think we can make improvements, and this is in line with what the President announced in January and some of the reforms we've undertaken, where I think we need to have a wider aperture on how we think about risk for intelligence activities, specifically the risk of indiscriminate, illegal exposure of intelligence activities. 2, I think we also need to think hard about how to bring the American people into the dialogue about digital privacy. And this goes to the point General Hayden was making earlier about the system. The compromise that's been in place since 1978 clearly seems to be insufficient in terms of public involvement in how we think about these issues.
I want to get Bob and Scott to talk on this, then I want to tweak the question for John.
So I won't repeat what Raj said, although I agree with everything he said. I think that the people who are suggesting that this is, that what's been exposed is on the level of what happened in the 1970s and led to the Church and Pike Commission, or people who talk about how we've created a surveillance state, are so far from the truth as not to really merit any serious response. We have, as Stephen Preston, the former general counsel of the CIA, now general counsel of defense, said in a speech he gave, intelligence is a heavily regulated enterprise. Mike Hayden made mention to that earlier today, that the extent to which we have legal, judicial, and oversight of our intelligence programs is unmatched anywhere in the world. And what I'd like to do is sort of give an overview of the process by which we commence intelligence collection and how we make the determinations that the programs are legal and right in your sense. We start, of course, with the Constitution and statutes passed by Congress. Congress has, in FISA, passed a statute that not only essentially requires an individualized court order based on probable cause in order for us to target any American anywhere in the world, but also imposes a degree of judicial oversight on collection of foreign intelligence about foreign persons outside of the United States. And I don't know of any other country in the world that requires the court to get involved in that, but we have that as well. And so those statutes impose limits on what we do. And to the extent that we are conducting activities that fall within those statutes, we fully abide by and comply with all of the regulations that Congress has and the procedures that Congress has required be followed. Second, as I mentioned, the FISA court is extensively involved in surveillance within its areas of activity. Third, by executive order, all of our intelligence activities are subject to rules that the agencies have regulating that require us to minimize the collection, dissemination, and retention of information of U.S. persons. All of our intelligence collection activities are subject to those. All of our intelligence activities are known to the intelligence committees in Congress, and everything under FISA is also notified to the judiciary committees. So Congress is kept fully informed of what we're doing in these areas. In addition to that, there's extensive levels of executive branch oversight. And I think it's very significant that in everything that has been disclosed so far, there's no indication that we have abused the collection programs for improper purposes, that we have been intentionally violating the law, that we've been spying on people for improper purposes, because we've got procedures in place that manage to prevent that from happening. There's a very extensive oversight structure. But legality is only part of the question that you asked. The other question is whether it's right. And I think it's important to understand that, as my boss at DNI says, intelligence is not a self-licking ice cream cone. The NSA doesn't go out and collect things just because they can or just because they want to. It starts with an interagency policy process that determines and prioritizes what are the subjects on which the policymakers need information, both to protect us from threats and to conduct our foreign policy effectively. And those are prioritized, and they're sent out to the intelligence community, and targets are selected and developed, and programs are selected and developed in order to fulfill those policy needs. So we're not just randomly looking to collect communications of U.S. persons or non-U.S. persons. It all has to be driven by valid foreign intelligence needs. And again, they're both for very practical and financial reasons and also for policy reasons. Periodically, we step back and look at what we're doing and say, are we getting our money's worth out of this? And in fact, I think it's publicly known by now that one of the more controversial surveillance programs, which was a program to collect internet metadata in bulk, was in fact stopped several years ago because there was a determination made, we're not getting value out of this. So it's not worth the costs or the risks of the invasions of privacy that this particular program encounters. So I think nobody should be under any illusion that these programs were not carefully thought through and carefully tailored in a way to try to not only comply with the law, but to secure important intelligence in a way that both protects privacy and attempts to minimize the risks.
Scott, how does this look for Microsoft?
So ever since the Snowden disclosures, the government has said essentially what it has said now. We followed the Constitution, we followed the statutes, we told Congress, the courts approved that no Americans were harmed in the filming of this movie. But in fact, when you listen to how the process can be improved, never do you hear the government say, as part of the national security calculus, the competitiveness of American industry is part of national security. You don't hear that. What you hear is national security means collecting things that the government needs. And when you say and come out and say, we followed all the rules, Americans have been protected, you have to understand that the American IT industry is globally dominant. More than half our revenue comes from overseas, and it has a huge impact on whether 5, 10, 15 years from now, we will still be the dominant and most competitive industry. And if you believe that our ability to compete effectively is important to national security, where was that built into the calculus? The answer is it wasn't. I suspect because the government said we don't have to build it into the calculus because these programs will never be exposed. But they have been. And so the real question becomes, you know, we've been talking a while now about this framework where you think about actors and objectives actions and impacts. A great example is security at the airport. The actor is the government. The objective is save planes. Everyone agrees that's a great objective. So they take an action. They put in metal detectors, and there are impacts. You find guns, but there are lines and some invasion of privacy. People go, that's the right thing to do. Then at some point, they put in X-ray machines. The actor is the government. The objective, save planes, still good. Action, X-ray machines. Impact. Oh, now you have a problem, because everyone knows X-ray machines caused Godzilla to attack Tokyo. There are these nude pictures of you that agents are seeing. The impact didn't justify that action. So they go to backscatter machines, which are radio waves with opaque pictures, and people go, okay, now I don't have X-ray exposure, and my privacy is protected. And I understand that the government as an actor has an objective to stop terrorism. That's a fine objective. And they took an action, snarf up the world's data. What is the impact of that? And they only looked at a piece of the impact, even from a national security perspective, only a piece of the impact. And I argue that they have to be more nuanced and think more broadly about these problems.
I agree. I agree.
Yeah, and I think if I could just say, I think that the presidential policy directive that the president issued in January specifically calls that out as something that needs to be taken into account in making decisions about signals intelligence collection going forward.
What Scott's talking about there is having a very narrow field of vision. And a question I want to put to John is, when you're a senior lawyer, the top lawyer for an intelligence agency, that's an unusual job. How do you approach it? How do you think about who is your client when you are the general counsel for the CIA? Is it the agency? Is it the director? Is it the public that the agency serves? I think you can get what I'm after here. Is there a tension? Are you there to find a way to get to yes for the operators, or are you there to protect the Constitution?
Yeah. First of all, I should emphasize at the outset, I spent a long time in CIA as a lawyer, but I retired at the end of 2009 after 7 particularly combustible last years there. So I must say, just sitting here listening to this debate about things that happened a year ago, I find it so bracing that I have nothing to do with any of it. So I feel so liberated. Well, Greg, to answer your question, and this is may have been my parochial perspective from being there and being there for so long, I viewed the agency as my client. That included the director, but it also included everyone down the chain of command, the analysts, the operatives, the scientists, the administrative personnel. They were all my clients. I honestly, I suppose if I had time during all those years to contemplate any of this, I would have said, well, I'm serving the American people as well. But honestly, my focus, I was busy enough trying to protect the people I just described rather than the American values, so to speak. Not that we were not unmindful of those, but that just wasn't my focus. Now, in terms of what I saw my role as, this memoir I published a few months ago.
Company man, available at your nearest bookstore.
Yes, yeah. And audiobook, I should say. Where was I? Some of the reviews, a couple of the reviews, alluded to the fact or said that, described me as a legal enabler for CIA. Now, actually, I took that as a compliment, although I'm entirely confident it was not meant as a compliment. I saw my position as a lawyer at CIA. It's a cliche, but these guys know it as well. It's very easy to say no to something. You never really get in trouble if you tell your client, don't do it, it's too risky. What I thought my role was, as all CIA lawyers have been, and these guys are carrying on that tradition, is to, first of all, assess where the legal lines are. First and foremost, establish that, then perform a policy role about risk, benefit. Is this stupid? Are you guys being too complicated here? And what's it going to look like if it shows up in the media. But ultimately, try to figure out a way, given those conditions and constraints, to allow our people to perform their core national security mission. So that's what I strive to do throughout my career. The first 25 years of it, I managed to do this in a quiet, unobtrusive way. It became more public and controversial in my last 7. But I mean, I hope that I was consistent in that kind of approach.
So what I'd like to do now is ask some broader questions, NSA surveillance-related questions. Then we're going to drill down a little deeper, and then we'll try to look forward a bit at the end before opening up to questions from the audience. So the first question here is for Raj. It's been more than a year since the first Snowden stories surfaced, and we've heard lots of conflicting claims by U.S. officials about how much damage they caused. We heard statements even today here on this stage that the main costs appear to have been diplomatic and economic, which suggests that maybe they weren't operational. And I was in a conversation last night with what we in the press like to call a senior administration official, who was saying that even in a case of tracking fighters into and out of Syria, this person had seen no real damage to that capability from the changes to 215 or anything else of those programs exposed by Snowden. So a year later, what is the real damage assessment?
I think there's a couple of things to keep in mind. One is, I would characterize the various statements that you've heard out there not so much conflicting in substance, but probably more in tone. That would be one suggestion. The second would be that most officials, senior intelligence officials, have view the world in a piece of the world. And it's very rare to have a global sense of everything that's happening. But with respect to the harm, I think there's 2 consistent themes that we've heard most senior officials articulate publicly and privately. One is, we are seeing targets communicate specifically about leaked information and indicating their intent to change how they're going to communicate. That's a fact. Secondly, even the president has acknowledged in his speech in January, and something we often repeat, it is unlikely to be known the full extent of the harm yet for years to come. This is the sort of disclosure that takes time in order for one to understand the full ramifications of what has happened. But moving beyond that, I want to articulate why I think it's so difficult to speak publicly about harm in this sort of situation. It's a complex for a few reasons. The first is that what you don't want to do is amplify some specific harm by speaking about it. So if it were the case that our collection posture was affected in a certain part of the world because of a particular disclosure, the last thing you want to do is speak to that publicly, because that will only increase the lack of visibility in that part of the world. Secondly, there's an ongoing criminal matter with respect to Edward Snowden, and I think it's prudent for most government officials, in fact, to not speak publicly about this matter generally. And third, as I said earlier, this is the sort of thing that takes, it's a dynamic assessment that frankly changes over time as more information is disclosed and as more pieces come together in the public sphere. But I would like to echo what I think you were referring to Juan's comments earlier today. That's a very narrow view of harm, operational harm. And I want to totally endorse what Scott was saying, is I think some of the underestimated harm here, certainly not by Scott or the people on the stage, but in the public, is the impact on the US economy based on unfair and inaccurate accusations against US companies, for example. The harm to our diplomatic relations, which frankly have second and third order effects that aren't visible to most of us every day. But anybody who works in this field knows that working internationally is a complicated, multidimensional task. And third, whether there's some setback to our public discussion on the need for cybersecurity. You know, over the last few years, we've had senior officials ringing the alarm bell about as significantly as possible. You had former Secretary of Defense Panetta warning of a potential cyber Pearl Harbor. You have the chairman of the SISI, the Senate Intelligence Committee, saying cyber is perhaps the greatest threat we have going forward. You have the Director of National Intelligence testifying at least 2 years in a row with cyber at the top of the worldwide threat assessment. If that discussion is set back because it's so dependent on public-private cooperation as a result of misinformed and ill-informed dialogue on some of the Snowden issues, I think that would be an unfortunate consequence that I would characterize as harm.
Scott, how would you add up the damage after a year for a company like Microsoft?
Well, it's really, I think that there's both the kind of known damage that Raj talked about, but there's a lot of hidden things happening, not hidden in secret, but things that are an outcome of Snowden that people may not have thought a lot about, that has huge implications both for the public-private partnership but also for going forward for national security. For example, because there were several allegations that came out of Snowden, but now there are really three memes, which I think people should understand. So the first allegation that came out was that the government had direct access to the servers of American companies. Okay, that wasn't true, it was never true, and it got debunked. But there are still kind of three things that you hear continually. The first is that the government is pulling all this data off the telecommunications lines, satellites, undersea cables, and the like. And as customers around the world got increasingly concerned about this, it created a major market force for the massive acceleration of encryption deployment. And all of the big providers came out and said, look, we're going to encrypt everything traveling between our data centers, everything traveling between our customers and us, and everything at rest. And so that's great for security, probably not the best thing for the intelligence community. But we had to react to the customer demands and concerns. So that was one meme. The second meme we heard was, you're an American company, you must be in bed with the US government. You just can't be trusted. And as the whole world is moving to these cloud services where you're aggregating all these data, and the major cloud providers are American companies, Amazon, Google, Yahoo, Microsoft, suddenly you have most of the world saying, we don't know that we can trust you with our data because you're in bed with the government. And so we've long had programs. We've always been principled in what we've done. We believe in security, privacy, and transparency. We don't put backdoors in products. We don't give encryption keys to the government. And we've made our source code available to other governments so they can look for themselves and verify, right? But that meme that we're just in bed and therefore not to be trusted is a problem when the whole model depends on trust. And then the third problem is that leaving aside what they might have been taking off the telecommunications lines, and even if they believe we're not in bed with the US government, customers go, but if we use your services, the government can come to you with court orders and take our stuff. And we are now in litigation in the Southern District of New York, contesting a government order that would require us to turn over data from an Irish data center. And typical with the issue I raised before about perspective, the US government says, well, you're a US company. If we give you an order here, you need to pull the data from wherever in the world it is. Okay, that's a US perspective. Let's say the US wins. Doesn't that mean in every country where we do business, a foreign government can give us an order to pull the mail of American citizens into their country? Reciprocity is hell in foreign affairs. When I chaired the G8 subgroup, I had a very clear, I said to all the countries right away, I have a very clear principle. I should be able to do whatever I want to you, but you cannot do it back. And they didn't buy it. And so, you know, as the government works through these things, an American company, what we have to do is make sure we're listening to our customers and not creating that perception that we're in bed. Having said that, we are not, and I want to be really clear about this, we are not moving away from working with the US government and all the other governments, Russia, China, they're all customers, as long as we're working on defense and information assurance. Look, governments have unique responsibilities and unique knowledge, and they're responsible for protecting critical infrastructure protection and security and privacy. We care about those things. If the infrastructure's not working, it's bad for our business. If our customers don't think the infrastructure's secure and private, it's bad for our business, okay? And so we want those things, and we have to work with government, and they have to work with us to achieve it. The key is being very principled, that you're working together to protect people and not to exploit them, that you're doing defense and not offense. And then you have to remember, of course, all technology is dual use, right? So whenever you tell, we give a government source code so they can see if we have backdoors, they can also look for bugs that they can exploit. I can buy a car because I want to drive to work or because I want to drive over my spouse. The car dealer doesn't know, and the car company can't stop it, right? IT is dual use. You can use it for protection, for defense, or offense. We have to be principled and work with governments on defense.
I didn't hear a dollar figure there. Does that mean that at Microsoft, you don't really have a clear sense of financially what the impact has been?
So we don't have like a set number, but I can tell you what the experience has been, and then two parts of that. One is we have customers overseas, as you might suspect. Germany is a good case in point, where they're going, we were thinking about signing up for your cloud services. We're slowing down that train. And you open markets for foreign competitors. Deutsche Telekom has said, we're going to create a German-only cloud. And that way German customers will choose us over these American things. And they see it as a wedge opportunity. And so on one hand, you see things sometimes slowing down. The second thing is, for governments and large customers, they have account managers. They talk to us. So when a customer you're negotiating with says we're slowing down this deal because of these allegations, you know. But we have a consumer business. We have 450 million Hotmail users, Outlook users. How many of those people are moving away from American products and services because of these allegations? Do you think they're calling me up to discuss it first? So there's a huge impact that you really just can't measure, and then there's the impact you know about because you're talking to customers all the time.
So now I want to try to drill down on a couple specific areas, and forgive me, it's going to sound like a conversation about, there's going to be so many numbers it'll sound like LA freeways.
Before we move away from this, I just want to add something. I know Raj said that government officials would consider it prudent in light of the criminal case not to talk about damage, but nobody's ever accused me of prudence. And so I do want to just relate a little anecdote that just happened to be relevant, because just a week or so ago, I was getting briefed on the activities of a particular dangerous terrorist group, seriously dangerous. And the young woman from the CIA who was doing the briefing, in the course of the briefing, mentioned that this group used to communicate using a particular form of communications, one of the ones that had been disclosed. But after the disclosures, they said to each other, we have to stop using this, it's too dangerous. And now we don't know what they're saying to each other. So it is just simply inaccurate to say there's not an impact. Will this result in dead bodies? I don't know. We'll probably never be able to tell. But it is definitely true that there are people who we want to know what they're saying, who we don't know what they're saying because of these disclosures.
So the Post published a piece a week or so ago by a former section chief for internet freedom at the State Department. And the thrust of it was, you know, for all of this hand-wringing over metadata 215, over the 702 program, what American people really need to be worried about is what the NSA is doing under Executive Order 12333. And basically laid out the case that through this authorization, the NSA is targeting foreign individuals for foreign intelligence purposes overseas, but collecting, incidentally, large volumes of Americans' communications, their chats, their photos, whatever, emails. And not only collecting it, but stockpiling it, holding it for years, and searching it with such frequency that the FBI can't even estimate how often it digs into this database. So for Bob and Raj, I think, why would we try to adjust the protections, the privacy protections for these programs that reside in the United States, but leave Americans so vulnerable and treat it so separately when the collection is happening overseas? Why wouldn't US persons be just as entitled, especially given the sort of global trends that Scott is outlining, why wouldn't they be entitled to just as much privacy when their data is moving around these nodes overseas as if they were in the US?
You want to start?
Yeah. So I think it's important to understand what Executive Order 12333 is to start with. Executive Order 12333 is not like FISA, a grant of power to conduct surveillance. It's a regulation of the intelligence community and a series of limitations on what each element can do. It prescribes the authorities of each element, and of particular relevance here, there is a section 2.3 of Executive Order 12333 that basically says anytime any element of the intelligence community collects information about a United States person, that information has to be subject to rules that minimize the collection, retention, and dissemination of information about the U.S. persons. Those apply across the board. They apply to all collection that the intelligence community does. Fundamentally, what this editorial was talking about was sort of the core foreign intelligence authority collection of the president. It's foreign intelligence conducted outside of the United States, directed against people who aren't United States persons. For example, to the extent we were doing signals intelligence collection in Iraq during the Iraq War, that was regulated by Executive Order 12333. All of the communications that aren't directed at U.S. persons and aren't taking place within the United States. So the notion that this is being done and it's sort of outside of regulation and that we can keep U.S. person communications indefinitely there is just wrong. It's subject to the same set of U.S. person rules that govern any other collection that we do.
I could just to build on that. So to answer your question about why wouldn't Americans be entitled to protections under 12333, they are. And that's what Bob was articulating. We have to have Attorney General approved procedures to protect the privacy of Americans in the conduct of 12333 activities. But one thing I'd ask you to do as you read articles that are out there, I'd ask you to apply the same rigor that you hopefully are applying to what we're saying up here to what you read. Now, I read the article, and I don't exactly remember, although I counted at the time. Somewhere buried deep in that article was a statement by the author saying, I know there are rules governing this sort of collection, but I'm not familiar with them. I think it was paragraph 14 in that article. I would have thought before I wrote something like that, I would familiarize myself with the rules. But getting to the bigger picture points that Bob was raising, in addition to Executive Order 12333, the President articulated some new guidance this year in a document called Presidential Policy Directive 28, which governs 12333 activities, signals intelligence activities. And some of the most relevant provisions of that are things like laying down the principles under which signals intelligence activities will be conducted. They must be as narrowly tailored as feasible, for example. It also articulates the principles for which bulk collection, the collection of information in bulk, can be used, a delimited set of exclusive reasons, things like counter-terrorism. And it also articulated the direction from the President that there need to be appropriate safeguards in place to protect the personal information of non-US persons in addition to US persons. And so as we think through these issues, it's also important to recognize that some of the changes that have been made over the past year.
Well, let me just tack on the President's Review Board alluded to this capability in its report and said that it believes this data should be expunged. Do you think that that's likely to happen? Incidentally collected data on U.S. persons overseas.
So I think one point of clarification, the Review Board was looking at, or the Privacy Board was looking at Section 702 as opposed to 12333. But the principle is still the same. And fundamentally, here's the dilemma that the intelligence community faces. Our rules require, if there's something that is clearly irrelevant to the foreign intelligence purpose for which information is collected, yes, it must be destroyed. The difficulty, the real tricky policy question is, when is that determination sufficient in a world where intelligence is determined by putting pieces together, often when you don't know the import of one particular piece of information in the context of other pieces of information, particularly information that may be collected subsequently. So to the extent there's a complex policy question there, that's the real issue, and it doesn't lend itself to a flip answer one way or another.
John?
I was just going to, on your question about the President's Review Group and 12333, we obviously could have a different set of rules. We could have a rule that says every time you identify a U.S. person's communication, you have to throw it out immediately. Of course, it would be a little bit perverse to have a rule that requires us to examine every communication that comes in, identify every person to see whether they're a U.S. person, and then determine whether to throw it out or not, because that probably would result in a greater invasion of privacy than just collecting the communications and just waiting until you have an opportunity to look at them. But we could have a different set of rules, but nobody should imagine that tightening the rules in that regard is not going to have an impact. There is information that we collect that turns out to be useful a year or 2 years later. We are going to, if we require greater stringency in what we collect and how much we retain and how we disseminate it, we're going to lose intelligence capabilities. What we've had for the last few decades is a system that says, we know you're going to collect some US person information in the course of valid foreign intelligence directed as foreigners. As one of my colleagues in the ODNI said the other day, there's no such thing as immaculate collection. So what we do to take care of that is we have these rules that Raj alluded to say if you happen across US person information, you can't disseminate it unless it's of foreign intelligence value. You have to get rid of it if it has no value. And these rules are not only developed by the intelligence community, but as Raj says, the Department of Justice has to look at them from the outside. The Attorney General is ultimately responsible for approving those. So that's the way we struck the balance.
John, you had something?
I must say, well, just briefly, when you talk about Executive Order 12333, this is now back in my era, so I feel a little more comfortable with that. I must say, just looking at this from a holistic perspective, that executive order was signed by Ronald Reagan in 1981. It has remained on the books under presidents of both parties ever since. Those Attorney General procedures were promulgated in 1981. At least as of the time I left, they had not changed. So this notion that somehow, I mean, there's a certain, I must say, a Captain Renault quality to some of the protests, especially about the executive order and its you know, this seemingly huge gaping hole or loophole that it has. I mean, these standards have been on the books and well known to succeeding generations of Congress for years and years and years. Why now suddenly do we have to now go back and fix this?
Because the standards are the same, but the world has changed.
Okay. Okay.
It's the same reason we have to amend the Electronic Communications Privacy Act, why we had to amend the Computer Fraud and Abuse Act. The world was not globally connected with cloud services where people all over the world were going to give their data to American companies. It's a different world.
So we're getting toward the end here. I want to get to some questions from the audience. One, I want to ask a double-barrel question for you, Scott, right at the end. This is in Microsoft has a company called Skype, a long time regarded as a secure way for people to communicate around the world. That's come under some suspicion because of Snowden-related allegations. Can you tell us whether, in addition to the government being able to compel a company like yours to turn over data that is transiting through your networks, can it also compel you to change your code? Can it compel you to change your products to enable it to get access to products like Skype?
So one, they have never done that, and two, we would fight it tooth and nail in the courts. So under the wiretapping statute in FISA, you can be compelled to provide technical assistance. But if they said, for example, put in a back door or something like that, we would fight it all the way to the Supreme Court. Look, if the government did that, and I really don't think they would, it would be at the complete expense of American competitiveness. Because if we put in a back door for the US government, we couldn't sell anywhere in the world, not even in America. I will tell you a funny story. When I first started going to China, they said, you know, you probably put in a back door for the NSA. And I explained that our market cap would go to zero overnight, which is something they really hadn't thought about. Although one person said to me, well, if you were really patriotic, you would. And it got a little funnier because we have registry keys in Windows. There are a lot of registry keys. They're long alphanumeric things that help Windows work. And many, many years ago, there was a registry key called NSA key. And we published a bulletin. It was an acronym. But when I was in China, they said to me, but what about the NSA key? And I said, if we were going to put a backdoor in for the NSA, do you think we'd name it NSA key? He didn't bat an eye. He said, that's why it's so diabolical.
All right, let's take some questions. There's got to be a lot. Right here, blue shirt. Please identify yourself and wait till you get a microphone.
Tom Baer, Mr. Charney, assume that you're a federal judge Article 3, exercising the judicial power of the United States in cases and controversies, about which there's a lot written, would you accept appointment to the FISA court?
Probably.
Okay.
Look,
thank you.
I used to be in the Justice Department. I don't think the court's sinister.
I'm not saying it's sinister.
Right.
I'm just asking whether you would accept appointment.
I believe in oversight. I believe in judicial oversight. I think there can be amendments.
Even if there's one party?
Well, I think, there's been discussion that maybe there should also be a privacy advocate, someone
Well,
at
but
the
that's not,
FISA
that's
court.
as of today, I'm asking.
No, but my point is, you can always, and I think Raj says this, there's always room for improvement in processes. And I think, we've been clear and others have been clear that our court system's based on an adversarial process, and the FISA court is not an adversarial process. And the judges would just be better informed if they had someone saying, before you sign this order, we want to explain some of these other things about how technology works and other things that the government may not have explained, not just because they have a point of view, and they're advocates, and they're lawyers. They represent a party. Well, who's representing the other side? The privacy side, the citizen side, and all of that. But I wouldn't shy away from, an appointment to a court that's job it is to make sure that people are playing by the rules. I think the bigger challenge is, in a globally connected world, we really do have to think what these rules should look like. That's the real challenge.
Okay, thank you.
We have somebody down here in the very front who I think knows something about Snowden disclosures.
I wanted to talk a little bit more about incidental collection. So you can't target Americans without a warrant, and if you inadvertently do target them, you discard the collection. And then there's a whole bunch of stuff that comes in incident to the collection on your actual target. And I don't know what your experience is in meetings, but if you say, oh, incidentally, toward the end of the meeting, oh, by the way, sometimes that hides a pretty big point. So a thought experiment, if we were to learn that the bucket of content that you've collected incidentally includes the conversations of 1 million Americans, or 10, or 100 million Americans, is there any number that you think American people should be concerned about? Or is it that or do you trust your minimization rules and procedures and your own integrity enough that you wouldn't worry about that regardless of scale?
So, as I said a couple of minutes ago, there's no way to avoid incidental collection. I mean, at a bare minimum, if we, and Bart wrote an article about this, if we're targeting a foreign terrorist, that person is going to be talking to lots of other people. Some of them are going to be Americans. We're going to incidentally collect the communications of those Americans. So we can't avoid that. And there are really two different approaches that you could take to that. You could take the approach that says, we're very worried about the possibility that you're going to be collecting a lot of Americans' communications, and so we don't want you to do this at all. Or you can take the approach that says, we're very worried about your collecting the communications of Americans, and so we're going to try to put in rules that govern what you can do with these collections that you're inevitably going to collect, that limit the extent to which you can disseminate any information about an American, that limit the use you can make of it, and limit your ability to retain it to a defined period of time. And obviously, we've chosen the latter course. I happen to think that's the right course to choose, that the alternative course of basically shutting down the communications would not be an appropriate one to do.
I just add one additional point, because I agree with Bart that the term incidental really is an unfortunate term, because it just doesn't capture what's going on here. We have targets. There's somebody whose communications you are trying to collect. By definition, a communication has someone else on the other end of it. And that's what we're talking about. Incidental collection means who's on the other end of the communication. The point of collection is to get two folks who are talking. This is not unique to the intelligence environment. This happens in the law enforcement environment as well. And that's why the FBI has minimization rules to deal with Title III or criminal wiretaps as well. Now, the way collection works is a little different in the criminal context and the national security context. And obviously that, I think, gets to what Bob was saying about the regime you set up and whether you're just going to cut out the ability to collect on certain targets because you're afraid of who they might talk to.
We only have a few minutes left. Can we just take 3 very quick questions and let's see if we can race through them? Okay, right there in the white shirt. Maybe 2.
My name is Tom Korologos. I'm a Washington junkie. Some years ago, the New York Times admitted they made a mistake when they ran the terrorist financing stories, breaking up the SWIFT program all over Europe. Can we expect, I'm asking Greg Miller this, can we expect something the same from Washington Post regarding the Snowden affair in some future year?
I doubt it. I don't recall that New York Times mea culpa either. Does anybody else? I'm not sure that they... With the SWIFT program? John McLaughlin, please. Last word.
No, he was just answering your question.
The last word, John.
No, he was just answering your question about does anybody remember the New York
Oh, he
Times?
remembers. Okay, so one last question. We only have a minute left right here in the...
It was buried in an ombudsman column that did not have a headline that led you to know what was in paragraph 12. Because the column was about something else, and down in the middle of the paragraph it said that I, as an ombudsman, have second thoughts about having previously endorsed the revelation of the SWIFT program because, thinking it over, it was not illegal, it was supervised, and it did no harm.
Well,
and now that was not the author of the piece, that was the ombudsman. So it wasn't a full apology or anything like that.
I shouldn't be so flip in the way I answered your question. I mean, the honest answer is at the Post, I've been involved in a lot of discussions about these stories, and I wouldn't ever claim that we achieved perfection on any story. So it's possible that we could reach a point where we see some eventuality we didn't anticipate and have to reevaluate a decision that we had made this past year. I mean, I think that we obviously stand behind all of our Snowden reporting, and I think that the point that General Hayden made in the previous panel about this sort of gap between the consent of the governed and the consent of the governors it has closed a bit because of this. I mean, we have seen significant changes in policy as a result of these disclosures, which suggest that there was some gap between the design of these programs and their execution and the public's level of comfort with them. So I don't mean to take the last word here, but I think I don't have any choice. All right, thank you.